Hi there. The main reason couples create financial agreements is to protect their property, the property of the couple who are about to get married or have already married. An apartment financing agreement is intended to protect an apartment that is owned by one of the parties, and with which he came and entered into a relationship. The purpose of signing a prenuptial agreement on an apartment is that in the event of a divorce, the other party may claim and demand rights in the property, even though the property was purchased before the marriage. Such a situation can be prevented by drafting and signing a financial agreement that excludes the specific property, the apartment, and the planned property division between the spouses. In order to make a financial agreement for an apartment in a correct and professional manner, it is recommended and essential to contact a family lawyer who will build and draw up a financial agreement for the couple that is precisely and personally tailored to their needs and goals. Diving property in a divorce. In the event of a divorce, the couple's property will be divided equally between them, based on the resource balance arrangement that appears in the financial relations law. In general, this division should include only such joint property accrued after the couple has married. However, there is another possibility to include personal assets bought by either party or those inherited before the marriage, based on the sharing rule that states that when an intention to share the property can be proven, it will be considered a joint property, i.e. one in which both parties have rights. Which of the parties comes to the relationship when he owns a significant property such as an apartment? The legal situation for him is problematic, because in divorce, separation, the property owner may find himself forced to share the rights in his apartment with his spouse, even though this apartment was purchased before marriage, and sometimes even before the relationship began. At the exact point entered, a financing agreement for an apartment enters the picture, which provides a legal solution to the problem. What is a financial agreement for an apartment? In the past, the majority of the population married at a relatively young age, and the couple started their life together from the same point, and usually almost without property. Today, many couples marry at a later age, and more than once. One of the spouses comes into a relationship when he owns an apartment or inherited an apartment from a deceased parent. As stated, in light of the rule of cohabitation, if a marriage comes to an end, the other party can demand to receive rights over the same apartment. In order to prevent such a situation, it is possible to make a financial agreement for an apartment that will clearly and explicitly state that the ownership of the property belongs solely to the party who bought it, while the other party will have no requirements if the couple decides to separate. Many people tend to think that making a lawful financial agreement is a negative thing, and if we raise the possibility or demand to make such an agreement, it means that we anticipate separation and divorce and assume that if we separate, our spouse will embark on a journey and retaliate to get our property. In practice, this is not the case, and the opposite is true. An apartment financing agreement allows us to provide each other with peace and security, that the relationship and the relationship are the main thing, and that we are devoid of any economic financial interest, so that if the day comes, we decide to separate, we will not demand any rights in the other party's property.
How do you prove sharing intent? As stated, without an orderly prenuptial agreement made by a family law attorney who is skilled in drafting prenuptial agreements, the spouses will be exposed to the intent to share. As part of this claim, each party may demand to receive rights and share from the other party's property and personal assets on the grounds that throughout the relationship and cohabitation, the property in question has gone from personal to joint. The burden of proof that there was indeed a sharing intent rests on the shoulders of the party claiming it, and the way to prove a sharing intent varies depending on the type of property. Intention to share may be expressed in both operative acts and various statements. In the end, the totality of the behaviors and conduct of the spouse who owns the apartment will be examined, and whether his conduct created in the other party a clear impression that the apartment is a joint property that belongs to both. In this regard, it should be emphasized that the form and manner of registration of the apartment alone does not constitute sufficient evidence here or there. This means that if the spouse who owns the property left the apartment as registered in his name only, but his actual behavior actually indicates intent to share, and the fact that he did not add the other party's name in the registration in the registry will be accepted and considered solely technical and not material. Of the lack of intent to share.
When and why should you make a financial agreement for an apartment? The very existence of a property owned by one of the spouses who are about to get married or have already been married, and the risk of separation, this apartment, the increase in value or property, an apartment that will be purchased instead of this apartment and may be sued by your spouse. Add to this the fact that the parents may have assisted in the purchase of the person who currently owns the apartment, and they will no doubt want to avoid a dangerous situation according to their method and ask you to sign a financial agreement with an expert and experienced lawyer. Family and drug preparation and legal contracts. Emphasis on drafting a financial agreement for an apartment. These are the clauses and points that are important to include and regulate in a financial agreement for an apartment. Renovation and maintenance. The financial agreement must stipulate that the party who does not own the apartment will never be able to receive rights to it or property rights in part of it, regardless of the circumstances. This section will include a situation where the other party assisted, planned, and invested his money in renovating the apartment, helping to rent the apartment, etc. Mortgage. It is important to arrange that even if the mortgage repayments are transferred from a joint bank account of the couple, and also if the other party did not participate in the actual mortgage repayments, then in any such situation, and despite the said payment transfer, the non-owner does not purchase any property right. Alternatively, it is possible to determine a refund to be transferred to him, but not any property rights in the property. Residence. If you intend to live in the apartment, it must be determined in advance that the actual residence in the apartment will not give the spouse rights in the apartment, and that the status of the other party in the apartment will already be defined as permission. In addition, it is important to determine in advance whether the spouse will be obligated to pay you rent in accordance with current financial arrangements and living arrangements, or whether he will share in the costs of maintaining the apartment. Electricity, water, gas, property taxes, etc., and will participate in repair costs. The clause and stipulation in a financial agreement on an apartment that your spouse will be exempt from paying rent are intended to protect him from a claim in the event of separation and an obligation to pay rent retroactively. Evacuation of the apartment in case of separation. It often happens that the party who is not the owner of the apartment, and in case of divorce or separation, he is supposed to vacate it, refuses to leave and vacates it. Such a situation will force and require you to file a claim for eviction that will be long, expensive, and unnecessary, even if you eventually win it. It may be considered to include in a financial agreement for the apartment the imposition of a daily compensation obligation in any case and situation of refusal on the part of the spouse to vacate the apartment.
Israel's Financial Relations Law. Section 5 of the Israel Financial Relations Law 5733-1733 refers to the division of property between a married couple or a person whose marriage has expired and stipulates that a balance of resources arrangement must be made. Were inherited or gifted during the marriage. According to the law, private property originating before the marriage, including money, gifts, and inheritances, residential apartment, movables, allowances, social rights, is not included in the property that will be divided upon the expiration of the marriage between the spouses. In recent years, in the Supreme Court ruling before the Honorable Justice Eliakim Rubinstein, the court has addressed this issue and given a precedent-setting decision that contradicts the Financial Relations Act, with a broad approach to contract law and the legal principles of justice and integrity. In light of the above, it is very important to draw up a financial agreement for an apartment. The importance of a financial agreement on an apartment. Today, many couples choose to make a financial agreement on the residential apartment or an apartment bought by one of the parties for the purpose of investment as well as the other assets and property of the parties. To draw up a financial agreement for an apartment in a professional, smooth, and fair manner, it is advisable to contact a family lawyer or specialist lawyer who specializes in drafting financial agreements and build a comprehensive and professional agreement in coordination and cooperation that will best protect the interests of both spouses. That he is likely to inherit in the future or as a gift a residential apartment, when it may occur when the couple is already married. When it comes to public figures, it will be even more important to make a financial agreement on an apartment. There are situations where the couple buys a residential apartment together, but each invests a significantly different amount in the purchase. For example, the woman invests 50% of the value of the apartment and the man invests only 20%, and together they take out a 30% mortgage loan on the balance. In order for it to be maintained and there will be a balance between the parties, it is worth signing a financial agreement for an apartment in order to clearly define the property rights of each of the parties in the apartment in case they decide to unpack the package. Drafting a prenuptial agreement on an apartment will prevent disputes and future disputes regarding the division of the rights in the apartment and will save high and unnecessary expenses in conducting a long, complicated, and exhausting legal process.
Drafting a financial agreement accompanied by an experienced lawyer and notary in the field of family law. The law firm and notary Scheiman Hahn provides comprehensive and professional legal services in the field of civil commercial law, drafting financial agreements and contracts, real estate, inheritances and wills, enforcement proceedings, and more. The firm's team of lawyers has extensive experience and expertise in accompanying and representing clients in a wide variety of veteran cases, in various proceedings, and in drafting agreements and legal contracts. Drawing up a financial agreement on an apartment is a wise and important step that will greatly contribute to managing a stable and healthy relationship and married life, so it is important to ensure that the procedure and drafting of the agreement is accompanied by an expert lawyer who will protect the interests of both parties. With every question, request, we are at your service, and we will be happy to provide you with professional advice, guidance, representation, and answer to any need until the task is completed on the best side.